Hello, I'm Jordan Garcia. I'm a partner at Nevada Family Law Group. In this video, I want to explore child custody. Child custody is made up of two different areas: legal custody and physical custody. Legal custody is broken up into two different types: sole and joint. Legal custody covers three different areas. The first is the ability to make decisions about the child. That would be making decisions about medical decisions, the ability to make decisions about which school the child attends. The next area it covers is the ability to access information about the child. That would be getting information on grades, information on medical records, other types of information about the child. The final area it covers is participation. That is participation going to a school event, volunteering at school, going to a soccer practice. That encompasses joint legal custody. And what we say is, when we say joint legal custody, that means that both parents have an equal say, an equal opportunity, and an equal choice regarding those decisions. Generally speaking, legal custody for most cases is going to be joint. That means both parties have an equal say and equal opportunity to all that information, decision-making capabilities. And what that means is if the parties cannot agree on a decision, then that matter has to be taken before the court for the judge to decide. In some rare cases, a party is given sole legal custody. Sole legal custody has to deal with when one parent makes all the decisions, has all the access to the information to the exclusion of the other parent, and has complete control over those types of information and access. Joint legal custody is the standard, and it's typically what we see, but in some extreme cases, the courts will award sole legal custody. Sole legal custody typically is only, though, when we have a parent that has extreme situations such as domestic violence, drug issues, or showing a pattern and history of making poor decisions that severely impact the child. So that is typically very rare. The courts want to make sure that both parties and both parents are fully involved and therefore have joint legal custody. The next area that we have is physical custody. Physical custody affects the amount of time that the child has with each parent. For physical custody, we have primary physical custody and joint physical custody. Joint physical custody is typically between 40 and 60% of the time the child must spend with each parent. That means that on average, each parent will have at least 3 days a week. Over the course of a year, that means each parent will have at least 146 days out of a year. It can be slightly more, slightly less, and you will still be considered joint custody, but that is the general guidelines that we use. To get more than that, more than 60% of the time, then you would have primary physical custody. Primary physical custody would mean you, as one parent, has the majority of the time. What that means for the parent that doesn't have that, they typically just call that visitation. The parents will then have to figure out how to set up that schedule. So the custody label does not have anything to do with the amount of time that is designated each week or over the course of the year for each parent. As long as it's more than 60% of the time, that parent typically has primary. How we figure that out is based on a number of factors that a court has to review if the parties cannot agree. The default in Nevada is joint custody. That is a preference under Nevada law. That means going into the court, the judge is going to typically expect parties to show them a reason why they should not have joint custody. To show that you should have primary physical custody, the court reviews a number of factors. These factors include very serious issues like abduction, child neglect, child abuse, domestic violence, but they also include a number of soft issues, including things like, do you encourage frequent associations with the child? Do you encourage cooperation with the other parent? Are you the cause of conflict between the parties? What's the relationship of the child with both of you? And do you support the physical, emotional, and developmental needs of the child? The court is not limited to those factors and can look at anything that is relevant regarding the best interests of the child, but those are factors that the court must look at. The court will weigh all those factors and determine what's in the best interests of the child. The court can only do that by going to a trial or evidentiary hearing. And at the trial, the parties will present evidence to show which of those factors favors what they prefer, and the court will ultimately make a decision if whether they agree that those factors weigh in favor with what that parent wants, and decide based on those factors the best interests of the child. If you have any questions or would like to discuss your matter with us, please contact us at Nevada Family Law Group.